All right, so we'll get started. Thank you everyone for coming today for our Student Loans 2.0 Navigating Changes to the System under the new budget bill. I'm Sharon Campo, a supervising attorney here at Legal Services of Long Island. Um, with us today, we have Nancy Neerman of the Education Debt Consumer Assistance Program from the Community Service Society. And we also have our supervising attorney, Vivian Storm, with EdCap, and Jennifer Maldonado, our staff attorney. All right, next slide. Okay, so first we'll just go over a little bit about Legal Services of Long Island. Then Nancy will go over the new era of student loans, strategies for tackling your debt, guidance for borrowers, delinquency, default, and collections, our contact information, and relevant links that you can use um, after this presentation. I did send out copies of the slides to everyone this morning, so you should have received them if you had registered before 10:30. Um, Once we have completed the presentation, I will be sending out copies of the slides again, most likely today or tomorrow. Next. Okay, so if you're unfamiliar with Legal Services of Long Island, we are Long Island's largest provider of free civil legal services, handling over 6,000 cases every year. We do handle direct representation, phone consultations, brief service, and referrals to other entities. We have offices in Hempstead, Islandia, and Riverhead, and our case handling staff include attorneys, paralegals, and social workers. And we have partnerships with community agencies, whether it's the Community Service Society, Empire Justice, Brighter Tomorrows, and other different entities as well. Next. These are our three offices. We do accept walk-ins. We're open Monday through Friday, 9 to 5. And we have our website, which has a plethora of information on all of our programs and past presentations and future as well. Next. We do have about 20 different units, varying in different areas of law or different populations, whether it's a domestic violence family court project, our mental health unit, our senior citizen law project in NASA, or our consumer debt unit, which I supervise in Suffolk County. But we do have the descriptions of all of our programs and on our website if you are interested in learning more. Next. And next, for our Legal Support Center for Advocates, this is specifically for advocates, whether you are an attorney working at another law firm or for yourself, or work for a government agency, maybe you're a social worker, caseworker, maybe you volunteer for your church. Anyone who's advocating on behalf of someone else is welcome to call us if you have questions on whether or not uh, whatever legal issue your client is facing, whether that's something that we can assist with, or maybe you need a little guidance or a referral. We host community trainings, we publish newsletters and emails with advocacy tips. So this is our extensions, my extension, Kathy and Hannah, that's specifically for advocates. Next. Okay, so now I'm going to pass it off to Nancy.
Thank you, Sharon. So welcome everybody. Today we're going to be speaking a lot about the changes that are going to be coming down the pike for student loans, and some of the things that are going to be new, some of the old things that are going away, and hopefully answer a lot of your questions in the process. So just a little bit of housekeeping before I start. I'm going to be doing the presentation, but we've got folks from Legal Services of Long Island, Vivian Storm and Jennifer Maldonado behind the scenes, who will be answering your questions. So if you have questions while we're doing the presentation, feel free to just type them into the chat, and they'll do their best to answer them. We'll break periodically to share some of those questions and answers with the entire group. So before I start, I just want to quickly introduce myself. I'm Nancy Neerman. I'm the Assistant Director of the Education Debt Consumer Assistance Program. We are a program initiative of the Community Service Society of New York, which is a nonprofit that's been around for about 180 years. The student loan program has not been around that long, although it feels like it has. We've launched in 2019, specifically the EdCap program, to deal with the issue of student loan debt. And have since expanded, and one of our EdCap partners now includes Legal Services of Long Island. Okay, so starting with the new era of student loans. So when you hear me refer to the OBBBA, this is the One Big Beautiful Bill Act, sometimes referred to as HR 1, that was signed into law last July, which covered a lot of different areas, not just student debt, but is having a significant impact on the student loan system going forward. So some of the changes that we're going to be talking about are changes to borrowing limits, changes to repayment options, some forgiveness programs, elimination of some short-term relief programs, um, just a lot of information. So we're going to start with the borrowing limits. Now, when you borrow as a student for undergraduate school, the student is allowed to borrow direct subsidized and unsubsidized loans for their undergraduate studies. If you're for that type of borrowing, there are no changes. So if you're a dependent undergraduate, you can right now borrow anywhere between $5,500 and $7,500 per year, up to $31,000 in aggregate to cover your undergraduate degree. If you are an independent student where you have to meet certain requirements, you're allowed to borrow a little bit more. So between, I think it's $9,500 and $12,500 per year, up to about $57,500. So none of that has changed. Where the changes really come into effect and come into play are when we start talking about graduate school. So direct unsubsidized loans for graduate school, if you're going for a master's degree, like a sort of a general master's degree, the annual limit is $20,500. That is actually no different than the current limit. But there is now a lifetime limit of $100,000 in aggregate for you to borrow direct unsubsidized loans to pursue a master's degree. If you're pursuing a professional degree, and I've got another slide that's going to break down the professional degrees that fall into this category, you will be able to borrow up to $50,000 annually or lifetime up to $200,000. Most of the degrees that have been deemed to be professional degrees are going to be law degrees or a lot of different medical degrees. Now, why this matters so much is because of the next bullet point, which is the Graduate Plus Loan Program. Graduate Plus loans allowed borrowers under the old system to borrow up to the cost of attendance. So they could borrow the difference between the total cost of attendance and any other aid they had already received, like from direct unsubsidized loans for graduate school or grants or scholarships. So that basically allowed all borrowers to fund their entire graduate school studies within the federal system. Well, starting July 1st of 2026, the Graduate Plus program is going to be eliminated. So new borrowers starting on that date are not going to be able to borrow up to the cost of attendance within the federal system. They're going to be limited to what they can borrow in direct unsubsidized loans for their graduate school studies. And that is probably for people that are pursuing more expensive types of degrees. There's probably going to be gaps in the funding, which they're going to have to turn elsewhere to fill, largely private loans. Likewise, the Parent Plus loan system program is similar to the Graduate Plus loan program in that it allowed parents to borrow up to the cost of attendance to fund their dependent undergraduate students. That's only for undergraduate degrees. So it would be the cost of attendance minus whatever other aid, federal aid, including student loans, grants, scholarships, the student received for their undergraduate studies. Now, they're not doing away with the Parent Plus program, but they are going to put some limits on this. So there's going to be an annual limit of $20,000 per child that you can borrow in terms of Parent Plus loans, and a lifetime limit of $65,000 per child. And that includes both parents. So they're going to be looking at the total borrowing between both parents. So once again, for more expensive private nonprofit schools, undergraduate schools, you may see families struggling to fund the entire thing within the federal system, and it's going to drive more people probably to either switching to cheaper schools or to finding alternative sources of funding, which a big chunk of that may well be private debt. Now, there is a grandfathering clause that applies to both PLUS loan programs. So if the student has a direct loan dispersed before July 1st of 2026, graduate students and Parent Plus borrowers can borrow under the existing rules, meaning that they can borrow up to the cost of attendance within the federal system. And they could do this for a maximum of 3 years, or until the student completes their program of study, or up to 3 years, whichever is sooner. But the big caveat here is that even though you're allowed to borrow under the existing borrowing limits, you're going to have to pay those loans back in under the new limits, under the new rules, which is going to have some significant consequences for Parent Plus borrowers. So this is a list of the degrees that now are considered to be professional degrees. These are the degrees that will be eligible for those bigger um, uh, borrowing limits, so up to $200,000 lifetime. There are apparently some additional degrees that fits under their specific definition of what a professional degree is under the new rules. It has to be at a doctoral level, require a certain professional licensure, and a number of other criteria. What is, though, notably absent, a few things that just to throw out there is most of well, pretty much all the nursing degrees, physician's assistants, masters of education, that's going to fall into the lower borrowing limits, masters of social work. Those all fall now under those $100,000 lifetime cap for borrowing in the federal system. Okay. So we're going to move on to repayment options. And I'm going to start with the SAVE plan, which has been very much in the news over the last month or so. And had I had time, I probably should have put a little roller coaster icon on this slide, because that's what it's been for the last couple of years, but particularly the last month or so. So just as a little bit of a recap, the SAVE plan was introduced during the Biden administration. It was going to be, for the vast majority of student borrowers, by far the cheapest repayment option out there. Had a lot of great features. Interest did not accrue. It was going to offer forgiveness anywhere from 10 years to 25 years, depending on your loan balance. But there was, shortly after it was introduced, a group of states in the Midwest sued the Department of Education, challenging the legality of the plan. A court placed an injunction on the Department of Education that prevented them from enrolling anybody in the plan or calculating payments in the plan. So everybody was thrown into this forbearance back in July of 2024. And that's where we've sat in that forbearance all this time. The forbearance originally started out as a non-interest bearing forbearance, but it became interest bearing starting August of last year. And you don't earn credit towards forgiveness while you're in that forbearance. Well, in December of this year, the parties to the lawsuit, which is a number of states led by the state of Missouri and the Department of Education, reached a settlement agreement that would basically end the SAVE plan almost immediately. A federal district court dismissed the litigation and refused to approve the settlement. And then an appeals court, literally 2 days ago, ordered the lower court to approve that settlement. So the parties appealed the decision to dismiss the case. An appeals court ordered the lower court to go ahead and then approve the settlement. And the lower court, in fact, did enter a final judgment approving that settlement on March 10th. So what does this all mean? So the SAVE plan was going to go away anyway in under the new budget bill. We're going to talk about all the changes to repayment plans in a minute. One of them was that the SAVE plan was going to go away in the middle of July. What this ruling means is that the SAVE plan is going to go away a lot sooner than that. So we don't know. We're still waiting on the Department of Education to issue some guidance to existing borrowers as to when they're going to have to transition out of this program. The initial scuttlebutt on this, when they talked about the settlement back in December, was they were going to give people a limited amount of time to transition out of SAVE into other repayment plans. But we still don't know what that is and what their timeline is. It could be that they just will give everybody until the new repayment plan system goes into effect in July, but we just don't know. So you need to make sure if you're in the Save Forbearance, you need to make sure that you're paying attention to all of your emails, your servicer inbox, so that you know what the timeline is for transitioning. Um, you can use the FSA loan simulator to start exploring alternative options. On the EdCap website as well, we've got a repayment calculator that includes a new plan that you won't yet find on the loan simulator. But just remember, you don't have to get out of the safe forbearance immediately, but at some point in the probably not too distant future, which is different, by the way, than I think, most of you who are in Save on your service accounts may be seeing that the forbearance is going to last until late 2028. That's not going to happen at this point. It's going to be much sooner than that. So, now's the time to start looking for other options because eventually you're going to be forced to get out of this plan. Okay, so what are the repayment plans for the future? So this is what's going to be available for what we call new borrowers. So this is anybody that takes new loans or consolidates existing loans on or after July 1st of 2026. If you do that, you are going to only have one of two options, or one of potentially two options. Um, Either the standard fixed repayment plan. This is a new tiered standard plan with where the payback period is going to range from 10 years to 25 years based on the size of your debt. So the maximum amount of time that you would have to pay back in this type of plan would be 25 years. That's going to be available to both student and Parent Plus borrowers. But here's where it gets more complicated. There's going to be one repayment plan that's based on your income. It's called the Repayment Assistance Plan, or RAP, and that is only going to be available to student borrowers with direct loans. And we're going to talk a lot more about this because this really has a significant impact on Parent Plus borrowers going forward. So Parent Plus borrowers will never have access to the RAP plan, even if you consolidate your loans. But before we get into those details, I just want to go over some of the calculations for RAP and some of the features of the plan. So it's going to calculate payments at 1 to 10% of adjusted gross income for incomes of $10,000 or more. The payment will be reduced by $50 for each dependent that you claim on your tax return. That's a less generous treatment of dependents and family size than you get with the existing repayment plans. The minimum payment is going to be $10. So under the existing plans, if you have very low income or no income, you can get on a $0 plan. Under RAP, you will be required to pay a minimum of $10 regardless of your income situation. Now, some of the better features of the RAP plan are that unpaid interest is not going to accrue. So this is actually similar to a feature in the Save plan where basically means that your loan balance is not going to increase as long as you make your required payments on time. If you have a payment that doesn't cover your interest, which a lot of people do if their income is moderate and their balance is high, that unpaid interest is not going to get added to your account like it does, what happens with the current repayment plans. In addition to that, if your payment does not cover at least $50 to bring your principal down, you will get a principal subsidy from the government of up to $50 per month. So basically, as long as you're paying your required monthly payment, even if it's as low as $10, you're going to see your loan balance decrease by $50 each month over the life of the loan. So there's no more like watching these loan balances balloon, which that's a good thing. Spousal income, if you're married, can be excluded for the purposes of calculating the payment if you're filing your taxes separately. But on the downside, there's no protected income and there's no adjustment for inflation in this repayment plan. There's no caps. So that just means as time goes on, it could be a little bit more difficult to make these payments. Now, if you remain in this plan and make your payments for 30 years and you still have a balance at the end, that balance would be forgiven. So that's actually 5 to 10 years longer than what the current IDR plans offer. But payments in the RAP plan are eligible for PSLF, and PSLF remains a 10-year path to forgiveness. So this is just a little bit of a couple of charts to give you an idea of what the payments might look like on the in the new standard fixed repayment plan on the left. So this is going to apply for all Parent Plus borrowers going forward, or new Parent Plus borrowers. This is the only plan that you're going to be able to make a payment in on your federal student loans. This chart is based on an interest rate of 6.5%. The payments will differ depending on what your interest rate is. On the right-hand side is just an illustration of what the RAP plan payments might look like and what the range will be, and how they apply the percentages to each income level. This chart assumes that you have no dependents. If you do have dependents, the payments would be a little bit lower, but no less than $10 per month. Now, what I want to talk about now is this kind of key rule under the new budget bill, which states that all your loans must be paid back in the same repayment plan. And this applies to students and to people with student loans and to Parent Plus borrowers. So what this means is that if you take out new loans or you consolidate existing loans, because when you consolidate a loan, it's considered to be a new loan, on or after July 1st of 2026, all your loans, even the older ones, are going to be subject to the new payment rules. So that means for student borrowers that you must pay all your loans in either the RAP plan or the standard repayment plan. For Parent Plus borrowers, it's even more important because it means that you must pay all your loans, including any loans you took prior to July 1st of 2026, only in the standard repayment plan. So you will no longer have access to income-driven repayment plans or forgiveness programs as a new Parent Plus borrower. Now, the one exception to this, actually, there's probably a few more exceptions, but the main exception to this is if you have both student loans for yourself and Parent Plus loans, you can pay the student loans back in the RAP plan, or if they're older loans, you might be able to pay them back in, no, actually, I think you would have to pay it back in the RAP plan. And you can pay the Parent Plus loans back in the standard plan because that's going to be the only option. Now I'm going to talk a little bit about legacy borrowers. So a legacy borrower, and this is our term, it's not the official term, is someone who does not take out or consolidate any loans on or after July 1st of 2026. So basically, you're done borrowing before July 1st of 2026. Obviously, July 1st, 2026 is sort of a key date in all of this. So if you're a legacy student borrower, you're going to be able to access some of the existing plans like Payee and ICR under the current rules up until July 1st of 2028. These two plans are being phased out under the new budget bill, but not until July 1st of 2028. So you will, if you're eligible, you'll be able to enroll in these plans up until that time. You're also going to be able to access the IBR plan. That's the one current plan that's going to continue to exist for legacy borrowers beyond July of 2028. Or the RAP plan, when that becomes available, that will become available on July 1st. So you'll be able to access any IBR and RAP until the debt is either forgiven or paid off. Now, just to refresh IBR, income-based repayment. And by the way, when I talk about going forward, when I talk about income-driven repayment plans or IDR plans, that's an umbrella term for all these other individual plans that we're talking about, like Payee, ICR, IBR, and RAP, and SAVE, as a matter of fact. So IBR plans under the new rules have no income test. They used to have an income test. If your income was very high in comparison to your debt and you weren't enrolled in the plan, you might not be able to get in. That's no longer the case. It is now pretty much open to anybody with direct or FFEL loans, as long as they're direct or FFEL loans. But there is a cap in this plan, so payments will continue to be capped at no more than the cost of the standard 10-year fixed repayment plan. Payments are calculated at 10 to 15% of discretionary income. That's a different calculation than RAP. Discretionary income actually factors in um, federal poverty levels, so there is an adjustment for inflation that doesn't exist in the RAP plan. And that, but which version of the IBR plan you're eligible for depends on when your loans were dispersed. If your loans were dispersed on or after, if your first loans were dispersed on or after July 1st of 2014, up until June 30th of 2026, you're eligible for the newer version of IBR, which is calculated at 10% of discretionary income, offers forgiveness after 20 years. If you have any loans that were dispersed prior to July 1st of 2014, your payment is going to be 15% of discretionary income and offers forgiveness after 25 years. So that's what's going to be available to legacy student borrowers. For legacy parent borrowers, it's a little bit more restrictive. It's a lot more restrictive. Um, if you are done with your borrowing and you want to retain access to income-based repayment and forgiveness programs, you must fully consolidate your loans and have those new consolidated loans dispersed before July 1st of 2026. If you don't do that, what's going to happen is that all your Parent Plus debt is only going to it will only be able to be paid back in a standard fixed repayment plan if you have unconsolidated loans. If you have consolidated Parent Plus loans, you've met this deadline, and then we can talk about the other things that you have to do, but it's not as close a deadline. Now, again, this is a completion deadline, not a submission deadline, so it doesn't mean that you can just submit your consolidation application on June 30th and you're good. You have to have the whole consolidation process must be completed by June 30th of 2026. So we're recommending that people submit these consolidation applications no later than April 1st in order to make sure that they're completed. It generally takes about 4 to 6 weeks to complete a consolidation, so there still is time. And I haven't noticed any sort of major backlog just yet, but as we get closer to this deadline, that could happen. Now, once the loans are consolidated, you must enroll in the income contingent repayment plan or ICR plan and make one payment in that plan. Now, I'm going to warn everybody, ICR can be a pretty expensive option, but you only have to make one payment in that plan, after which you can switch to the income-based repayment plan. So Parent Plus borrowers did not used to be able to access IBR. The only plan that they could access was ICR after they consolidated. You will be able to access IBR, which for most people will actually be a cheaper repayment plan. But you must go through this process of making the one payment in ICR, and then you'll have to submit another application and apply for IBR after this. In terms of enrolling in ICR and making that one payment, you just need to do it before it's phased out. It's going to be phased out in July of 2028. They may stop enrollment sometime before then. I'm sure they will. So we don't recommend that you delay doing this. Once you're consolidated, you should probably just get in, make the payment, and then move on. And just a reminder that older loans consolidated on or after July 1st of 2026 are going to be considered new loans, which means that you will throw all of your loans into that category of having to pay back under the new rules. So we're putting out a call to action for Parent Plus borrowers. Again, you want to get those loans consolidated before July 1st, enroll in ICR, make the one payment, transition to IBR. Parent Plus loans dispersed on or after July 1st of 2026, you're not going to have any access to RAP or modified RBR plans. You'll have no path to IDR or PSLF or IDR forgiveness for any of your Parent Plus loans if you take out a new loan on or after July 1st of 2026 or consolidate after that date. So you want to begin the consolidation and the IDR enrollment process now. If you took out new loans for spring of 2026, those should be ready to be consolidated. Even if you selected a deferment status, as long as the status on your accounts just says deferment, you can still consolidate. If it says in school, you need to contact the servicer and tell them to remove that status before you can consolidate. But I doubt that Parent Plus loans at this point would say in school. And then if you're planning to borrow on or after July 1st of 2026, because you might be in the middle of this process, you're going to be locked into that standard plan for all of your debt, at least all of your Parent Plus debt. So here's where, and I think that we never would have thought that we would, recommend that people consider taking out private loans, but you might need to consider alternative strategies. And I'll just give you an example. If you maybe have been funding your child's education with Parent Plus loans for 3 years, but they still have 1 year left, and you yourself are pursuing public service loan forgiveness, you borrowed most of your debt, you might want to consider a private loan for that last year so that you can retain access to IDR and to forgiveness programs for the bulk of your debt that you've already acquired. Okay, I'm going to stop there, Vivian, and see if there are any questions that we need to address.
The only question in the chat was just a question about the difference between the IBR plan and pay for new borrowers. Whether there's a reason people might want to stay in the pay plan for now until it expires.
So if you're eligible for both payee and the newer version of IBR, you should not be in the payee plan. You should be in IBR. I mean, frankly, I mean, it's okay. It's pretty much the same, payment calculation. Um, but just knowing that the payee plan is going to be phased out, there's no reason to be in it if you're also eligible for IBR, the newer version of IBR. Now, we do have clients that are only eligible for the older version of IBR, but are eligible for payee. For those people, there is a significant difference in the monthly payment. Those are the situations which, if you can still get into payee, we would advise that you be in payee. You can still earn credit towards public service loan forgiveness and towards income-driven repayment forgiveness in payee, and though that credit will be transitioned to the IBR plan or the RAP plan when you switch in the future. But that's a good reason to kind of, be in payee, but not if you're eligible for IBR for new borrowers. Okay, that's it.
Yeah, I'm on that. I'm just thinking that for people who don't have a substantial difference in the monthly payment between the two plans, IBR may provide a somewhat more secure, stable guarantee that you're really going to get the income-driven repayment
Yeah.
forgiveness that you're entitled to at the end of the process, because it does have somewhat better legal authority and has been less subject to challenge.
Yeah, that's a good point. Yeah. Not that it's being challenged, the rules have been set, but things don't always function as they according to the rules that they set. Okay. So now we're going to talk a little bit about sort of strategically trying to figure out a long-term plan for tackling your debt, because when clients come to us, they generally have an immediate issue that they have to try to address, which is they can't afford their payments. They may be about to go into default and they want to avoid that, or they're in default and they want to get out. And of course, we're going to address all of that. But we also always like to leave our clients with a long-term strategy for getting out of their debt, for eliminating their debt, because after all, that's everybody's goal, is to get rid of this. So we start with, within the federal system, identifying if there are forgiveness programs that you might be eligible for. So the big ones are going to be things like income-driven repayment or IDR forgiveness. So this is going to forgive balances after you make 20 to 30 years of qualifying payments in one of these IDR plans that we've been describing: IBR, payee, ICR, and RAP. There is no employment requirement for IDR forgiveness for this particular program. So this is going to be the default forgiveness program for borrowers who have significant debt, moderate incomes, but they don't have the kind of job that might qualify them for shorter forgiveness through, say, the PSLF program. Now, any credit that has already been accumulated towards IDRF in SAVE, payee, and ICR is going to be transferred to the income-based repayment plan or the new RAP plan, if that's what you choose going forward. So you're not going to lose credit that you've already accumulated. However, we do have to caution here, and I think now with the most recent court ruling on SAVE, if you consolidate, if you're pursuing IDR forgiveness and you consolidate your loans at this point, you're going to lose any credit that you might have already accumulated towards IDR forgiveness if you consolidate it. That was actually one of the SAVE regulations that was challenged, and since they have now pretty much struck the entire regulation with maybe a small exception, you need to be careful. If you're in that situation, you probably want to reach out for some one-on-one help before you move forward. Forgiven balances in the IDR forgiveness program may be taxable starting this year. Although I will just say a caveat here, if you're one of these people that has had your loans for a very long time, and you're starting to get these letters saying that you're eligible for a discharge, check to see what the effective date of that discharge was, because if the effective date of the discharge was last year, which it is for many people, they are not going to tax you. It's only when the effective date becomes 2026 that you may be taxed on this. And then, of course, we've got public service loan forgiveness, or PSLF. So under the PSLF program, you make 120 qualifying monthly payments. So that's 10 years, after which the remaining loan balances are forgiven. And a qualifying payment is defined as an on-time payment made in full on or after October 1st of 2007. That's when the program started. So any payments that you made before then apply to your loan, but you don't get credit for that under PSLF. You must have direct loans. You must be in one of the income-driven repayment plans, or some payments in the standard 10-year fixed repayment plan will count as well. But remember, if you stay in that plan for the entire 10 years, you'll have eliminated all the debt. There will be nothing left to forgive. So eventually you would have to transition to an IDR plan. And then you have to meet the employment requirements. So you have to be working an average of at least 30 hours per week for one or more qualifying employers. That would be generally nonprofits or governments. If you have more than one job, you need to be working those jobs concurrently so that the total hours average at least 30 hours per week. The payments do not have to be consecutive. You can work in the public sector and earn 3 years of credit towards PSLF, then move to the private sector for a few years and come back a few years later. You will not have lost the 3 years that you've already accumulated. You just pick up from where you left off. If you are at the time that you apply for forgiveness, so basically at the time you submit that last form that says that you're at 120 qualifying payments, you must meet the employment requirements. So you must be working an average of 30 hours per week for a qualifying employer at the time you submit that last application. So if you're thinking about retiring or moving to the private sector and your last payment you believe is due on April 10th, make sure you make that payment and then submit your form while you're still at the qualifying employer before you move on. And then there's something called PSLF buyback, which is a big deal for people who have been stuck in the SAVE forbearance, which allows you to purchase months spent in disqualifying payment statuses. Now, that does not include things like school deferment, grace periods, or default, or you cannot purchase months prior to consolidation. But you can purchase months that you might have been in the SAVE forbearance and other types of forbearances and deferments that you have been in over the course of the years. So the buyback process is out there, but the process is really, really slow. Like the way they're processing these applications, apparently it's very labor intensive, and they have not assigned a lot of resources to doing this. And the estimated time now to clear the backlog, which just keeps growing every month, is about 3 years. So we'll talk a little bit more about this in the guidance, but we're not discouraging people who are eligible for the buyback from submitting the request. We just maybe don't suggest that you rely solely on the buyback to get yourself to forgiveness, because you could be waiting a very long time. Forgiven balances in PSLF are not taxable at the federal level or in New York State. There's been a lot written about the taxability of student loan forgiveness programs, and a lot of people get that confused and think that PSLF is going to be taxable. It is not. The taxability question really pertains to the IDR forgiveness program, which I just spoke about. PSLF borrowers should continue to file their employment certification forms. That's the PSLF certification form. This is what verifies that you've met the employment requirements, and this is the only way to update your qualifying payment count officially. So you must submit one form for every qualifying employer that you've had since October 1st of 2007 or later if your loans were taken out later. We generally recommend that you submit the forms annually or whenever you change jobs. There's no deadline for doing it, but you won't get an official count until you get everything up to date. And remember, once you submit the form for a particular employer, it doesn't automatically update. People seem to think that you submit the form once and then, every year it's going to give you updated numbers. That doesn't happen. You have to continually submit the form if you're with that employer to update the count. In terms of how you do this, we strongly recommend that you use the PSLF help tool from your studentaid.gov account and request an electronic signature from your employer. If you submit the forms this way, you should get a very quick turnaround and a very quick update of your qualifying payment count and the PSLF tracker. Anything submitted with a manual signature these days is taking eons to process. So if you can avoid that, we strongly suggest that you do it this way. And then the total and permanent or a disability discharge or TPD discharge. This is if you have some kind of a physical or mental disability or chronic condition that prevents you from engaging in the activities required to sustain a livable wage. So it doesn't mean that you have to be completely bedridden. In fact, it doesn't mean that you can't work at all. You just have to meet certain criteria, and you can do that either if you're a disabled veteran, if you're on SSDI, SSI, or Social Security retirement, and you meet certain statuses and requirements there. If you don't fit into one of those first two categories and you can get a medical professional to sign off on a certification form, that's another way to get TPD. Now, TPD, the way they process these applications changed last year. It all used to be done through the servicer Nelnet. They switched it over to the Department of Education. It has not been a smooth transition, but is hopefully starting to get a little bit better. If you need help submitting the forms, you should reach out to LSLI and they'll help you. Okay, so once you've thought about your forgiveness options, you're now going to kind of choose your strategy. And we have generally found that most people are going to fall into one of three buckets. The first bucket is pay your debt off in full as quickly as possible. So this is going to be for people who have higher incomes in comparison to their loan balances. They have the ability to make more than the monthly required payments or make lump sum payments. If this is the strategy that you are pursuing, the faster you get the loans paid off, the less you will pay overall because you're saving in interest. And if this is your strategy, sometimes the traditional repayment plans are a better fit, although IDR plans can work for this strategy as well. The second bucket, which is where most of our clients live, is to identify a forgiveness program that you might be eligible for and make the minimum required payment until such time as you receive this forgiveness. So this is a very viable strategy, and I think a lot of people don't completely let this sink in, that there are viable strategies within the federal student loan system that do not require that you pay your entire debt off. But it does require that you identify where you might be eligible for a forgiveness program. And if there is no realistic expectation that you can pay the debt off in full before you can receive that forgiveness, this is the strategy for you, where you just identify the forgiveness program, make the minimum required payment. Generally, it's going to be in an income-driven repayment plan, and then eventually get your debt forgiven. And if that's the path that you're pursuing, you really don't want to make extra payments on your debt because it's not helping you get to your end goal any faster. And then the last bucket, which sounds a little bit depressing, but we have it here for a reason, is to pay the minimum required until death do you part. And the reason that we put this on here is because unlike other types of consumer debt, federal student loans are dischargeable in death. So that means if the primary borrower passes away, the debt obligation does not accrue to the decedent's estate. It does not accrue, it does not become a problem for their family or their beneficiaries. And this is really going to be largely for older borrowers who maybe have taken out late in life loans for themselves or have a lot of Parent Plus debt. They're approaching or in retirement, so the PSLF option is really not there for them any longer. And they realize that they're going to have to be paying their loans for, 20, 25, or even 30 years. And of course, if you're 50 or 60 or even 70 years old, that's pretty much going to be the rest of your life. So the idea here um, is just find the cheapest plan available to you, whether it's a traditional plan, and a very extended version of that, or an income-driven repayment plan, and make that payment knowing that when you pass, it's not going to be a burden for your loved ones. All right. Getting on to guidance for borrowers. If you're enrolled in income-based repayment, payee, or ICR, you want to keep making these payments to earn PSLF or IDR forgiveness credit. Just remember that you will need to switch out of payee or ICR after July 1st of 2028 if you're still in that in those plans, and if you still need to make payments. And as I said earlier, IDR forgiveness credit accumulated in Save, Payee, and ICR will be transferred to IBR and to WRAP, so you won't lose that accumulated credit. Now, you're thinking, might there be a reason that why I might want to remain in the Save forbearance instead of just looking to get out of it immediately? So the Save forbearance still does offer temporary relief. It doesn't require that you make a payment. Nobody's being kicked out tomorrow. So if you can't afford to make the payment right now, you can remain in the Save forbearance. My thinking is that it's not going to be that much longer, maybe several months, maybe 6 months, I don't know. But it's going to give you a little bit of time to figure out a different strategy. If you think that your income is going to decline soon, whenever you switch repayment plans or whenever you submit an IDR application for any reason, you're enrolling in the plan for the first time, you're recertifying a plan, you're recalculating the plan, or you're switching the plan, you must submit proof of recent income. So if you're thinking that your income is going to drop in the coming months, you may want to remain in the Save forbearance until the income does drop, at which point you will have the proof of income to then get a lower payment. Or maybe you've looked into it and the WRAP plan is actually going to be the best option for you. But that plan's not available until July 1st, so you can remain in the Save forbearance if it's around until July 1st, and then switch over to the WRAP plan. Like I said a little bit earlier, there are ways to kind of figure out what your payments may look like in some of these plans. There's the FSA loan simulator on studentaid.gov. There's the EdCap repayment plan calculator, which does have, which will allow you to calculate your payment in WRAP. Again, that payments plan's not available yet, but you can see what it might look like when it does become available. And the WRAP option is not yet on the federal student aid website. So if you're pursuing PSLF and you're in the Save plan and you meet the PSLF buyback requirements, there are specific requirements for being able to do the buyback. You must have 120 qualifying months of employment on record, and the months that you buy back must get you to 120 qualifying payments. So if you meet that, those requirements, go ahead and submit the buyback request. There's no downside to submitting it. But we're also suggesting that you look into switching into a new income-driven repayment plan and making payments to earn additional credit for PSLF. So that's because of this long back wait time for a PSLF buyback application to be processed. It could be 3 years, and that backlog is going to grow, and it could take even longer than that. So I think that most borrowers that were in the save forbearance who meet the buyback requirements probably have somewhere between 15 and 20 months um, that they need to make payments before they get to public service loan forgiveness. That's going to get you there faster than waiting 3 years for a buyback request to be processed. But you can do both and see whichever one gets you there faster. For all other borrowers who are in the SAVE plan, now's the time to really start taking a look at that and looking to switch. If you're ready to do that, you can you can do your switch plan application on studentaid.gov. If you're able to connect to the IRS database during the process where they will bring in your last tax return, if that's what you want as your proof of income, then the application should be processed relatively quickly, or it might be processed relatively quickly. But if you have to upload proof of income, which sometimes happens, it could take a little bit longer. But I think now's the time to at least start exploring your options, if not actually filing the applications to switch. Okay, and I just wanted to say a quick word about student loan delinquencies and defaults, because this is kind of a big deal. And I have some breaking news. I didn't have a chance to update this chart, but the December numbers just came out. You can see here, these numbers on this chart were from September of 2025, where there were about 5.262 million borrowers in default nationally, 279,000 of them in New York State. Well, the December numbers have come out. The actual numbers of people in default nationwide now is 7.784 million. So that's about a little over 18% of all student loan borrowers. And there are now 434,000 New Yorkers that are in default on their loans. That's about 17.5% of all New Yorkers are in default. In addition to that, there's another 1 million or so who are significantly delinquent in that 271 to 360 day delinquent category. So it's very possible in another month or two, or certainly by the end of March, the total number of defaults nationwide could be close to 9 million borrowers. We'll have to see, but these are big numbers, and there's going to be a lot of people that are going to need to do something about this. So just quickly to review, what does delinquency and default mean? In the federal system, after 30 days delinquent, you're going to be assessed a late fee. After 90 days of delinquencies, they're going to report your delinquencies to the credit agencies. And at 270 days, which is about 9 months, you become at risk of default. Now, when you're in default, what that means is your loans are payable immediately and in full, which of course is a non-starter for most people. You have no access to income-driven repayment plans, deferments, forbearances, forgiveness programs, and then most importantly, you're subject to involuntary collections. The good news is that with federal student loan defaults, there are ways to get out of default. There's two ways. You can consolidate your loans, where you would just replace your old defaulted loans with new consolidation loans that are in good standing. Or you can go through a loan rehabilitation process where you make 9 monthly payments on time and in full over a 10-month period. There's pluses and minuses to both of these things. I'm not going to go into that detail now. If you're in default, we strongly recommend you reach out to LSLI for a consultation, and they'll try to, go over what is the best strategy for you. But a word about involuntary collections. So involuntary collections are suspended. This is another one of these roller coaster rides where they were going to restart them, and then they stopped them, and then they restarted them again, and then they stopped them again. The most recent news is that they're on hold. They didn't say for how long. Our best guess is that at the earliest they would start them up again mid-year, but could be longer than that. What this means, though, is the typical ways that the federal government goes about involuntary collections on defaulted borrowers is with administrative wage garnishment, tax refund intercepts, and Social Security and other federal benefit offsets. So none of that should happen if you have a defaulted federal student loan that is held by the Department of Education at this point, but at some point they will restart collections, and they may not give you a lot of advance notice. So if you're in default, now's the time to take advantage of this period where you're not subject to these things, and get yourself, a strategy to remove that default. And just a reminder that only loans that are actually in default are subject to involuntary collections. If you're just delinquent, you're not going to be subject to involuntary collections. The one thing I will say for any Parent Plus borrowers who may be in default and your loans are not consolidated, you want to reach out immediately for some help. Call LSLI, schedule appointments. If you contact the default resolution group, which is the debt collection arm of the Department of Education, they're going to walk you through the rehabilitation process. That's going to take 9 to 10 months or more. And by the time you're done with it, you will have missed the opportunity to consolidate your loans to retain access to IDR and forgiveness programs. So defaulted Parent Plus borrowers that are not consolidated, reach out immediately for help. And this is just this is the sort of synopsis of consolidation versus loan rehabilitation. Consolidation generally is a lot faster. Not everybody is eligible for one or both of these options, depends on your situation. A couple of things though, you cannot consolidate a loan with an outstanding wage garnishment, and you cannot consolidate or rehabilitate a loan that has an outstanding court judgment against it. And finally, this is the contact information for LSLI. We can reach them by phone or by email. And of course, everybody is going to get this once the presentation is finished. They'll send out the decks. So I'm going to stop there. And Vivian, we can finish up with any lingering questions.
Yes, there was a question about how and when spousal income would be included in calculating an IDR payment.
So yeah, and this is a really good question because it's the right time of year for this. So if you file your taxes jointly, and that's the last tax return on record at the time that you go to submit your IDR application, the payment is going to be based on your combined income with you and your spouse. So if you're, let's say, just an example, you filed your taxes jointly in 2024, you haven't filed your 2025 taxes yet and you're also thinking about filing an IDR application, and you're considering filing your taxes separately to reduce your student loan payments, you would probably want to wait until you submitted your 2025 tax return that shows that you're filing your taxes separately, so that the payment can be based on your income alone. And by the way, there's a lot more analysis that goes into this. Just as a reminder, generally, if you file your taxes separately, you're going to, in most instances, it benefits you from a tax perspective to file jointly versus separately. So you maybe wind up paying more taxes if you file your taxes separately rather than jointly, which is why we always tell people, we'll give you what the impact will be on your student loan payments, but you need to consult a tax professional to determine what the impact is on your taxes, so you have both numbers and you can make an informed decision. The other thing is, if you're a married couple and you file your taxes jointly and you both have federal student loan debt, there's a payment adjustment that may make it more palatable for you to file your taxes jointly, even if you're paying slightly more in student loan payments. But that's something that you would want to reach out for individual counseling on. A couple of other things. If you last filed your taxes jointly, but you're now separated, or there's a little box that you can check off that says, I cannot access my spouse's finances. If you can check either one of those, then you should be able to submit income, just your income, and have the payments be based on your income alone.
One thing that we've seen sometimes is that when you are applying for an IDR plan, there may be a request for spousal income, even if you are filing separately, but it shouldn't be actually included in the calculations ultimately.
Right, right. And they will also sometimes request uh information about the spouse. So they may request, particularly if you're filing jointly, they may request the name, the I think the social security number and the date of birth. But again, that does not obligate your spouse to pay your loans.
Another question was about the processing time for PSLF or IDR forgiveness once you've reached the magic number.
So I mean, it's a little bit hard to say with PSLF. I think the PSLF processing, first of all, it's easier to tell when you've reached PSLF because you're going to, once you submit those PSLF certification forms, if you do it the way that I described earlier with the electronic signatures, you can get a pretty quick update and you may see your count go to 120 qualifying payments. There's still going to be probably a good 3 to 6 weeks or possibly more, depending on who your servicer is, before you actually see the loans discharged when that happens. But remember, if you're submitting that last PSLF certification form that you are pretty sure is going to get you to 120 qualifying payments, you can request a forbearance when you submit that form so that once you're at 120, they put you in forbearance so you don't have to worry about making a payment. And if they don't do it automatically, you can call and ask for one while you're waiting for the loans to be discharged. For IDR forgiveness, that's a trickier question. It's not as, there are ways to kind of figure out where you may be in this process. We have a link that kind of, we call it a backdoor link that you can plug into your put into your FSA account, and it will come up with a qualifying payment count. That's as close as we can get to an official count, but it's not, there's no tracker on on your um there's no tracker on your federal student aid account. So the best way to figure out where you are in the process is to kind of use that link. Again, you may have to reach out for a consultation to do that. Once you see that you've met the requirements, like let's say you have 300 or more qualifying payments, there's not a lot you can do. There's no form that you file to jumpstart the process. It's supposed to happen automatically. What you can do is if you think you're there, you can call your servicer and ask them if they can see when you're scheduled for a discharge. But the process is that if you do hit that threshold, it seems like the Department of Education process these things in batches. And they may do it once a month, once every other month. What happens is you would get an email saying that you're eligible for a discharge. You have an option to opt out of the discharge, which people generally only do if they're worried about paying a tax on the forgiven balances. And if you don't respond to that, then the loans are eventually discharged. Now, how long it's taking them to get from the time they send the letter to the time the loans are actually discharged is kind of an open question at this point. They're telling people, I think, 30 to 90 days, but it's too soon to kind of tell exactly what's happening on the ground. But once again, once you get that letter saying that you've met that, the requirement, if you don't want to make any additional payments, you just call up and ask for a forbearance on your loans while you're waiting for the discharge.
Another question was about tax considerations for people who may be eligible for IDR forgiveness as well as PSLF. I would assume around about the same time.
Well, I mean, obviously, if you can do PSLF, that's going to be better. I mean, I think a lot of the people who are getting the letters saying that they're eligible for IDR forgiveness now were probably, those letters should have like an effective date on them. And if the effective date was anytime during 2025, you're not going to get taxed on IDR forgiveness. But going forward, all things considered, if you're going to hit both at the same time, you probably want to go with PSLF because that's not taxable.
I think that addressed all of the questions that weren't just fully resolved in the chat. If there's anyone with any other outstanding questions, you wanted another clarification, please feel free to put it in the chat, and I'll read it out to Nancy. Okay, I don't see anything else coming in. So thank you very much, Nancy, for a very timely and informative presentation. We'd really encourage anyone who is a Parent Plus borrower with unconsolidated loans, or people who are in default or just wondering what to do as the SAVE program comes to a close to reach out to us. And we look forward to working with you. Thank you.
Thank you, everyone.
Thank you.
Thank you. If
Thank
you
you.
can please complete the survey after you exit Zoom, we'd really appreciate it. And we have another presentation on the shelter share coming up on March 31st. So I'll send that out to everyone today or tomorrow. Have a great day, everybody.